mention item number 11, Lordship.
If I am for the applicant, Lordship.
Matter may come up immediately after Bihu.
Why it is in order column?
Lordship, I have filed this
I.
deposit 50% of my awarded amount, Lordship, since the appeal is pending before this honorable court.
Otherwise, you are the claimant.
Lordship, I am the respondent, Lordship, the claimant, Lordship.
No, the MSC was filed
The
by the
main appeal
company.
was filed by the insurance company.
Insurance company, Lordship.
But I,
You
which
are the
is
claimant respondent.
A claimant respondent.
So you have deposited 50%
No,
No,
I have filed this IA
for withdrawal of.
no, for asking them to deposit 50%
Oh,
of the awarded amount.
Achha. So you want an adjournment, please.
some time may be granted, Lordship, because some difficulties also there, and we need to obtain instructions also from the insurance. Immediately after Bihu, Lordship.
Lordship, 21, Lordship.
You are Mr.
SP Sharma.
SP Sharma. For the board of the the matter be listed on 21st,
21st.
21.
Lordship.
Obliged.
Obliged. Yeah, please, Lordship.
Lordship, I wish to mention for listing orders, Madam Lordship. Listing for orders,
Listing of a matter for orders.
Lordship.
It is of
19,
no. It is of which year? Case is of
25,
2025.
25.
You are listing under 19. No? On
Maybe. Item number 10, I want to see the LCR, you know, just to flag mark the relevant point of it.
So why it is in order call? One I is there.
I is there.
I is for
Withdraw the amount deposited by the. There is a point of insurance policy, or the insurance policy was not.
no, whatever they have already deposited the amount.
Yes,
So
I am
withdraw.
the appellant. I have deposited them.
You are the appellant company.
Company.
Achha.
Yes, yes, sir.
Oh, good.
Right.
My lords, the lower court has wrongly entertained the second suit. I would like to request honorable court to call the lower court record.
So we're challenging the order dated 29/11. Have you annexed the order here? Order you have annexed here?
Yeah,
In which page?
first
What page?
page is not mentioned, but I have annexed before
The order which you put to challenge you have
certified
annexed,
copy I have annexed.
huh?
CRT IO I-26.
Original case, you are the respondent, you are the defendant.
I am the petitioner,
No, petitioner defendant.
defendant.
Your MS? Your good name?
Hiramani Talukdar Roychuli.
Hard MS H. Talukdar, petitioner. This is a
My lord,
Fine.
humble request. Lord,
under section 115 CPC, setting aside the order passed by the learned civil judge junior division number Kamrup dated 29/11/25. 25. Wrote to the who responded to the post and process. For this year. Petitioner will take steps within 1 week. So we calling for the case record.
yeah,
But
my lord, humble
You
request.
also take steps for the respondent.
Much obliged.
Maybe Lordship is a transfer petition for transfer of material proceeding from the port of Udalguri to Guwahati. I am on behalf of the wife,
Udalguri to Guwahati.
Guwahati.
You are the wife.
The wife.
So presently case is pending before the court of district judge. Udalguri.
Yeah, district judge Udalguri.
So you are the respondent there.
I responded there.
What is the stage of the case?
A notice was issued to me. I've received the summon. I'm annexing the summon at Annexure B, page 19, Lordship.
So after receiving the
Yes, summon.
summon, you have appeared.
No, the appearance date is 17/1.
17.
17/1, Lordship.
Department. It's an application section. CPC bring home bracket T number 35 of the 2025 pending in the court of district judge Udalguri. Some with the court of principal judge family court and issue notice to the sole respondent to speed post and also call for the scan copy. Any further prayer you have?
No, Lordship, the proceeding may be state.
See, this is a very initial proceeding. You have not
Lordship,
appeared also.
Lordship.
It.
Lordship,
So it's just one appearance. Maybe you appear maybe once.
Lordship,
Then in the meantime, we'll listing it after 4 weeks. If it
Lordship,
necessary, then definitely we'll hear the matter.
Lordship.
List after 4 weeks.
Appellant's Lordship, impugn order, my lord, page number 42,
Page number
42, my lord.
42.
40, from 40 to 42, my lord. My lord, brief fact of this case is that, my lord,
The order was passed in the Turtle execution.
yes, madam. My lord, in the year of 2022, my lord, the revision petitioner entered into a land sale agreement, my lord. Accordingly, he has paid 14 lakhs something out of 19 lakhs, my lord. After 2.5 years, my lord, when the respondent could not execute the registered sale deed, I filed a title suit, my lord, in the year of 2025, my lord. After receiving the summon, the respondent, my lord, settled the matter outside of the court. Accordingly, my lord, both petitioner and respondent file a joint petition along with a compromise agreement before the court below, my lord, that is Civil Judge Senior Division, Goalpara, my lord. Accordingly, my lord, a compromise judgment and decree was passed by the court below, my lord, directing to pay the remaining balance amount, my lord. Thereafter, I have paid the remaining balance amount of 5 lakhs. After passing the decree, my lord, by the court below, my lord, that is Civil Judge Senior Division, Goalpara, the defendant did not comply the judgment and decree, my lord. Thereafter, I file a title execution number 26, my lord. In that title suit, my lord, the respondent approached to me to settle the matter. Accordingly, we file a compromise agreement along with a joint petition before the court below, my lord, that is Civil Judge Senior Division, Goalpara, my lord. The impugned, my lord, order is, my lord, page relevant portion is, my lord, page 41, my lord. The court below, that is Civil Judge Senior Division, dismissed my execution petition, my lord. That is why I have filed this revision petition, my lord. Page 41, my lord, from last 9 lines from bottom, my lord. May I read, my lord? Moreover, may I read, my lord? Moreover, filing another compromise agreement at this stage is redundant and meaningless. In a compromise should settle outside the court, it is the duty of the parties to abide by the decree and hence cannot transfer the burden to the court, which is already overburdened with the litigation of more serious nature. Considering the above discussion, in the interest of justice, execution is dismissed as there is no difference of opinion between the parties in respect of the compromise decree. Well, I want to submit one judgment of this Honorable Guwahati High Court, my lord. In this judgment, my lord, the Honorable, my lord, Para, my lord, 7, my lord, 7 and 8, my lord. The Honorable High Court held that in a suitable suit, the court, that is executing court, can always invoke the provision of section 151 of CPC, recording the compromise of the nature arrived by the parties, unless the terms and conditions by the lawful agreement. My lord, we have submitted a joint petition along with compromise agreement that is lawful, my lord, which is notarized, my lord. And accordingly, this Guwahati High Court remanded the case to the court below, directing the Civil Judge Senior Division, Morigaon, to pass a decree after recording the terms and condition of the compromise agreement in execution proceeding also, my lord. May I read the para 7, my lord, 7 and 8 of the judgment of the Guwahati High Court, my lord. I have gone through a copy of the affidavit Annexure 3, jointly shown by the petitioner and respondent number 2. Examination of this affidavit mistakenly reveals the existence of the terms and conditions of the compromise. Paragraph 1A to F of the affidavit describe in details the rights of obligation of the parties after compromise. One critical examination of the said terms and conditions, I do not find herein an unlawful agreement. The learned civil judge has clearly failed to apply his mind. I have noted the affidavit in opposition dated 10/8/2004, respondent number 1 and 2, in which they fully supported the case of the petitioner. the learned civil judge has also gone astray in holding that compromise petition could not be acted upon since it was filed very belatedly. True, there is no specific provision in the Code of Civil Procedure for recording the compromise at the stage of execution, but there is also nothing in the code which prevents a court from enforcing such a compromise. Order 23, Rule 4 of the code merely lays down that Rule 3 is not applied to the execution proceeding. In suitable cases, the court can always invoke the provision of Section 151 of the code for recording the compromise of the nature arrived at by the parties herein, unless the terms and conditions by unlawful agreement. It is a settled law that a source of power is traceable. Exercise of such power cannot be declined merely because it was invoked claim under a different provision of law. Under the circumstances, the manner in which the learned civil judge exercises his jurisdiction is improper, warranting the interference of this court. For
Here, your case is a bit different. Question is that
in this case, my lord, they have
but
filed.
here court is not make any observation that your petition is unlawful or unlawful compromise decree. It was a decree, compromise decree,
Yes,
lawful compromise decree.
yes, my lord.
But what bound you to make another application here?
My lord, they after
the
issuing
case?
notice, my lord.
Immediate execution of your sale deed.
Yes, my lord.
Then why you have come and with another compromise petition? There was no.
My court
no
was issued
fee.
notice, my lord.
Huh?
Court was pleased to issue notice, my lord.
Notice
To
to
that,
have to issue.
yes, my lord. They
So they have appeared.
appeared. They
You
have
just
appeared and filed, my lord.
can finalize the date and the execution for the sale date. What bound you to make another application for compromise and all? No need. There's not a requirement because your decree was a compromise decree earlier, but they have not complied with the decrees. That's why you have filed.
Judgment debtor.
Otherwise, I didn't find any
Well, judgment
irregularity in the order
debtor-
passed by the learned trial court.
Judgment
Rightly
debtor
passed the order.
received the copy, my lord. After receiving the notice, my lord, they approached the execution court, my lord.
But the petition was filed jointly by you, na?
Jointly, my lord.
Then why?
They
Why jointly by you? Once they fail to comply with the order, then again you have filed it jointly.
Look, they have
Now what
approached that.
remains? Even if suppose the execution case is dismissed or whatever, you can very well approach to the competent authority for your execution because compromise decree is still with you. On the basis of said compromise decree, you can approach a competent authority for the execution of the sale deed. You have filed the title execution for why? As because they have not complied with your the compromise decree and they have not executed the sale deed in your favor. That's
Yes,
why you have you have to approach the execution court.
Yes, my lord.
But if they are ready, even if after dismissal of the execution, what remains is then a decree is along with you only. It is only execution is dismissed, not the decree. The decree is still with you. On the basis of that compromise decree, you can approach a competent authority for execution of your sale deed. If we have arrived at a settlement with the other side,
That
I
we
think it is any wrong order anyway.
in my lord.
No, this case is different. Your one is different. Your
My lord,
Mr.
this case is similar nature,
No,
my lord.
not
In this
similar.
case also
Your
joint
name is-
petition filed, my lord.
Your good name.
What's Islam, my lord?
Mr. S. Islam, the Learned Constitution. It's an application under section 115 CPC, dated Article 227 of for revision of order dated 27/11/2025 passed by Learned Future Senior Division Kolpada in title execution number 26 of 25. So issue notice to the sole respondent of which has been dated. So call for this year, let the matter be accordingly listed. Immediately after you will do,
Okay, my lord.
immediately after. But if you go by the record, it is not your
Terms and condition has not been recorded, my lord. Terms and condition of the joint petition as well as compromise agreement has not been recorded in the order, my lord.
Whatever I'm saying, even in spite of suppose your dismissal of your title execution, your decree is still with you. That is the compromise decree on the basis of which you can approach the competent court for execution of the sale, it will be executed in your favor
My lord,
because remaining 5 lakhs you have already paid.
yes, my lord, no.
Then you have complied with the decree.
Decree,
Down it is their part, so we will execute. If they are agreed, as per your submission, they are agreed to compromise. They agreed to compromise means what? They agreed to execute a sale deed in your favor.
yes,
That's
my
why they have approached the court and we filed a compromise petition that we are ready. So if we are ready, so what remains? Nothing remains.
lord,
If you
the
think
terms and
otherwise,
condition
that
has
will
not been recorded, my lord.
Huh?
Terms and condition has not been recorded, my lord. We
Let
jointly
not be recorded.
Hmm.
Okay,
create
we are fixing
for a
it after
direction,
4
my lord.
weeks. If you kept fixing it after 4 weeks, in the meantime, you have a talk with the other side. If they are agree to execute a sale deed in your favor, the matter ends. Okay.
My lord, there is another annexer, annexer, my lord. Annexer, my lord, 11 and 8
No,
and
we are not
9.
going to build all the
8 and
annexures
9.
now. Okay, we are fixing it
Come
now.
Please, Lordship. This is an appeal against the award of MSD Testful, Lordship. We are the insurance company here, Lordship. The grounds of our appeal is the Lordship. Error committed by the land tribunal, Lordship. First of all, that here the claim petition as well as the award, Lordship, shows there is only one claimant. But
Only
it-
one claimant.
only one claimant, Lordship. But the award has been passed against 4 claimants. And the award has not been apportioned against the 4 claimants. Only in the award portion, let's say order portion, against the claimant, in favor of the claimant, the award has been passed. This is the one ground, Lordship. This judgment is silent about how those other claimants has come into picture. Whether any amendment petition was there on and again the another
Because it is a debt claim.
debt case, Lordship, and this is for 70 years old, Lordship. And there is another thing that I can see that the 2 of the claimants were minor. It's hard to believe that a person of 70 years has 2 minor children. There is another ground, Lordship. And Lordship, in the same line, Lordship, love and affection has been given to 4 dependents, 40,000 each. If there is a one claimant, Lordship, how can 4 can get that award, Lordship? That is, we have to see, Lordship. LCR will reveal everything, Lordship.
So is the claimant initially represented the other minor?
Claimant claims to be the wife of the deceased.
So she represented the other minors or
But it is in the award also, Lordship, in the claim petition, I can see, Lordship, there is only one claimant.
one claimant, whether
Might be, Lordship, but there must be something, some evidence there must be that they are the children. And 2 are minor children. They say that 2 are minor children. How can 70 years old man have 2 minor children? It's one thing. Something must be there in the evidence. They are the dependents. So, Lordship, we can deposit 50% also in this case. There is stay petition, Lordship, stay, and we deposit.
regarding withdrawal, do you want to say anything? now?
Nothing. In this case, Lordship, otherwise a genuine case. But there is some calculation or there is some mistake in this case regarding this apportionment. Apportion is not given. Entire amount has been given to the claimant, wife. If there is some other claimants, they should also get. That part is to be decided.
Parties to which about the line of the application. Selected. Against judgment and court, it's 27/10/2025. Passed by learned member MSCT Sonitpur Tishpur in MSC case number 56 of 3 23. This submitted by Mr. Mohammed. There is the finding of the member MSC is yes, and there is no clarification at all regarding the apportionment of the share awarded in this case. Considering the submission made by Mr. Mohammed, appeal is admitted for hearing. Issue notice to the respondents. How many respondents now? Two.
Here, Lordship, the respondents,
One
two
is
respondents.
One is the claimant and two is the owner rider.
Owner rider, Lordship.
Those people also called for DTC. They demand according to this as well as it I this is an application for stay of impugn judgment and award dated 27/10/2025. Passed by learned member MSCT Sonipur Tejpur in MSc case number 56 of 2023. Praying for no, the till the disposal of the incident. It is submitted by Mr. Korma, the learned counsel for the they are ready to pay the 50% of the awarded amount. Awarded amount. In view of this, that the execution of judgment and awarded so and so be stayed till disposal of the MSc appeal, subject to payment of 50% of the awarded amount within 6 months. With the above observation, the I stands. Let them appear, then only we'll pass the order.
Lordship, Lordship. How bless you, Lord.
Please, your lordship. But
Yes.
this is an appeal against the quantum of compensation. What is it?
Quantum only.
The quantum of compensation. I'll deposit 50% against.
The withdrawal will pass on their appearance only.
Yes, sir.
Let them file a petition, then it will pass. Heard Mr. the learned counsel for the appellant. An appeal under section 173 MD Act against the judgment and awarded at 18/9/2025. Learned member MSCT Golaghat in MSc case number 187 of 2023. Filed under section 166 of the MD Act. It is next submitted by Mr. that the present appeal has been filed, challenging the quantum of the award as by the learned university. Appeal is admitted here. Issue notice to the respondent. How many respondents are here?
Okay, respondents are
One.
one only, Lord.
One?
One.
Here Puspa Gogoi, one claimant. Then owner is two.
Owner is number
Rider
2,
is
Lordship. Navakuma Gogo and Papu.
other three respondents
Yes, sir.
to then adhere also called for DTC. They demand to be according to the I are going to deposit 50%.
50%.
Same order, 50%. It go within 60 from the date.
Okay. Okay, Lord.
I
6.
May it please your lordships. My lord, this is an appeal filed by the insurance company lordship against the judgment dated 12/11/25 by the MSCT Gwalpara lordship. Here lordship, the ground is that lordship, the claimant is the husband lordship. And it is observed by the learned members that he has his own income, he has his evidence, and he has admitted that he has his own income. And the son is major lordship. In spite of that finding, lordship awarded huge compensation under the head of loss of dependency. Lord. So far as loss of dependency, there is no loss so far as the claimant is concerned. Lord.
but the as a
At the-
wife or
as a-
mother
No,
or a
the wife,
housewife,
for the death of the wife, lordship.
No, no, yes, yes.
Yes.
As a wife,
Yes, yes.
as a mother or
Yes.
as a,
Yes, these are conventional heads where we are agreed to that. They are allowed for conventional heads. They are entitled to that.
because
is,
her service towards the
Yes,
entire
definitely,
family.
Lordship.
is
That is their lordship. Only the loss of dependence. We are on that only. Only loss of dependence. Except that they are entitled.
was 15 lakhs,
Lordship 15 lakhs and
52,000.
52,000. And if Lordship will come to the calculation part, that is, they will, loss of dependency is given 20 lakhs 58,000. Page 20, Lordship. And the rest is their entitled. I have also filed a petition for stay.
Whether it was any wrong calculation is there.
Which one,
I
Lordship?
don't know. Here, loss of dependency
Yes, Lordship.
also after deduction and all. Na?
Yes, yes, yes. Future
Total,
prospect
total
added.
loss of duty 13 lakhs.
Yes, yes, 1372. Considering the loss of, this is future prospect, including future.
Future prospect was also included.
Yes, including future prospect, the loss of dependency comes to rupees 13,72,000. The other heads, they are entitled.
The future question of future prospect will not be
Yes.
there. But anyway. RMS learn it. Yeah. So that we can instead 12/11/2020 was by Ranil member MSCP Walpad in MSc case number 176 of it. So they refer this appeal as the wrong calculation made by the Ranil member MSc, wherein the huge amount of money has been awarded towards loss of is admitted, issue the respondents to register, to repeat post and their costs also for listing. Yeah. So they did do. They are going to deposit or what?
Lordship, we are going to deposit, Lordship. That is the amount granted under different heads, Lordship. That is amounting rupees 1,80,000. Amount.
In that case, we have to hear the case.
Lordship.
We are going to issue notice with that.
Yes,
For
Lordship.
you, you're not going to submit 50%. So let
50%,
them
yes,
appear,
Lordship.
we'll hear the matter and then accordingly pass it.
Lordship.
Okay. So in I also, you just issue notice.
Lordship.
We are issuing notice.
Lordship.
Because only that head you are going to pay. No? That's why better to hear the other side.
Lordship, then admitted amount is 2 lakhs. If the Lordship may subject to deposit of 2 lakhs, they will file an application for that withdrawal. Then Lordship may hear the matter entirely.
That's what I'm saying. For stay,
Lordship.
generally we used to pass 50% of
50%,
the
yeah.
award. So in here you are going to pass a particular amount of 2 lakhs or something. So
Yeah.
let them appear. We'll hear the matter.
Then Lordship may stay the matter subject to deposit of 50% and let them apply for withdrawal of that. In that case, Lordship may hear the
But
matter.
in that case, you are going to if you already pay suppose 50%.
Yes, yes, Lordship.
Then that's
will
why
be
I'm saying
difficult.
that it will be
Yes,
may
yes.
be difficult. So
Lordship.
let them appear. We'll pass your.
Yes.
I have to still notes.
Must oblige, Lordship.
May I please, Your Lordship? My lord, this is an appeal filed by the owner of the vehicle against the judgment and order passed in MSC case number 1052 of 2018 by the impugned order and judgment dated 19/10/2024. My lord,
You are the owner driver.
I'm the owner, not the driver, my lord.
Okay.
I'm the owner. Here the tribunal, the tribunal has directed the insurance company to pay the amount and recover the amount from the owner of the vehicle. My lord, the contention is that the DL of the vehicle was not valid.
DL was not valid.
DL was not valid. My lord, the Honorable Tribunal has failed to appreciate the evidence of DW 1 and 2. And DW 2 has very specifically stated that yes, my lord, I may be permitted to come to first DW 1, my lord. It is page number 49, my lord. Page number 49. It is the official from the regional, it's the official of the insurance office, my lord. They have exhibited one document being Exhibit C, my lord. Exhibit C is page number 55, my lord. Wherein, my lord, it is stated, my lord, page number 55. With reference to the RTI letter dated 4/9/2028, the office of the undersigned would like to inform you that the driving license number so and so issued in the name of Sri Jayanta Patar, son of so and so is no more valid for legal purpose as per the Transport Commission Office Memorandum headed so and so dated Iman issued in continuation of his earlier public information so and so dated 1 August 2014. The memo states that those DL in paper formats which are not converted to smart card are nullified and shall be treated as cancelled or invalid. Therefore, hence the driving license's question is null and void and may be considered as invalid and cancelled. Now, the point is that at that the driving license was there. It was not valid only on the point that a notification was issued by the DTO Nagaland that it has to be turned to smart card, my lord. My lord, now coming to DW2, my lord. DW2, who is the owner of the vehicle, who has specifically stated in his WS as well as in his evidence that he has, at the time of appointing the driver, has checked the DL and has checked the driving skill of the driver at the time of appointing the driver. And that part has never been challenged by the insurance company, my lord. My lord, if we go through the judgment, first,
He checked his competency, whatever. These are your case. This is your case. But the question remained that there was an opinion by the court that at the relevant time your driving license was not the valid license. That is the case.
yes, my lord.
So, heard Mr. C. Fupon, the learned counsel for the section 178 against the judgment and award dated 19/10/2020 passed by learned member MSC number 3, Kamrup M. Guwahati in MSC case number 1052/2018, whereby present petitioner, whereby the appellant was directed, whereby the insurance company was directed to pay the compensation to the claimants with a further direction for recovery of the same from the present appellant, who is the owner of the opening. Next part is submitted by Mr. that the learned court below did not scrutinize the evidence on record properly and not appreciate the fact that the driving license at the relevant time of accident was not a was a valid driving license. So, due to some notification passed by the concerned government, your master card was not provided to the driver. Next, will be admitted yet issue notice to the all respondents to speed post and as usual process, and also call for this. The matter be according to district 4 weeks as when it did to it. What is the IA for?
I for stay, my lord.
See, what is your, as per the direction of the court, whether the insurance company has already deposited any amount?
My lord, I came to have an information that the insurance company has filed an appeal in this
They
matter.
have also filed an.
Yes. Uh,
Have the number of these.
yes, my lord. It is numbered as 343 of 2025.
343 or. I to
MSC appeal 343 of 2025.
further considering the submission made by Planet Council, Mr. Cook. Let the present appeal be tagged along with MSC appeal number 343 of. We are going to pass, going to issue notice at this stage only, yeah. Let
My
the
lord.
other record, it may be already state, I don't know, the execution of the may be state. As you have submitted that 343 has already been filed. Let the record become, then we'll see.
Yes. My lord, then both the matter be taken together.
Yes, yes, we're passing the order for taking together.
Okay.
We'll try, better to try both the matters together.
Well. Okay. May I please, Your
Yes.
Lordship, there is an appeal prepared by the insurance company, Lordship, whereby we have challenged the principle of pay and recovery that has been applied by the learned tribunal. The insurance company proved that the driver did not have a license with the endorsement to drive a vehicle for carrying hazardous substance. It was an oil tanker. So there was violation of policy condition. And the learned member also discussed the entire thing and considered the evidence also, but later on applied the principle of pay and recovery. So that is our main ground.
Department Special Sharma, the learned counsel for the appellate. This is an appeal. The section 173 MP Act against the judgment and award dated 16/9/2025 by learned member MSCT. Nagaon in MSC case number 1/22. It is submitted by Mr. Sharma that basically they have challenged the principle applied by the learned member MSCT of pay and recovery. And in the same time, it is also seen that the learned trial court below did not consider the fact that there was a policy violation of, or there is a policy violation by the appeal be admitted for the issue notice to the respondents to speed post and
Also, can it be only by usual process, Lordship? If possible.
notice to usual process. Also called for the DCR. Let the matter be according to the 4 weeks.
So there is an IFR stay and we are ready to deposit 50%.
Regarding disbursement, withdrawal,
Disbursement, Lordship, let the
later.
owner appear first.
Just be sure they done it also for the applicant. This is the petition by the first day of the judgment and award dated 16/9/2025 passed by learned member MSCT. Nagaon in MSC case number 182. Is for the MSC. Experiment Sharma is they are ready to pay 50% the amount awarded. In view of this, the execution of judgment and awarded in Suez passed by Suez case number 12. We state till disposal of the connected MSC appeal, such payment of 50% the awarded within 6 with the above observation, the IS
50 of Lordship. Lordship, deposit within 6 weeks.
6 weeks.
May it please, Your Lordship.
Yes.
But we have preferred this appeal paying for enhancement, my lord. So at this stage, notice will go, man.
Pardon, Mr. S. Dust, done it council for the Citizen Appeal, section 173. and the judgment and award dated 3/10/2025. Done it member MCT Warbeck in MSc case number 465 of it. It is submitted by Mr. Steve present with challenging the quantum issue notice to the respondent to speed your process. Have to be admitted. We will be admitted for hearing issue notice webs or they demand listed after 4 weeks.
After 4 weeks, man. Highly request.
No, this I for releasing the amount deposited by the insurance company.
Yes, have you gone through the record and all?
Yes, my lord. In this case, your lordship, there are two vital points are involved in your. First of all, the insurance policy itself is not issued by our company. Your. And this point,
Not by your company?
yes, my lord. Actually, whatever they have submitted before the learned court below, this was a fake insurance policy, not issued by our company. In our WS, as well as we have adduced evidence also, in which we have clearly mentioned that the policy was not issued by our company. So we are not liable to pay any amount in this case. Your. But that point was overlooked. Your. I have the flag mark this in the lower court judgment. Lower court
matter may be hard matter full length matter.
No, at this stage,
Matter they have already deposited 25%. By simple ways to release the amount.
No, that
You
was
might
the-
have the objection, man. Then you will also fix the matter for hearing my final hearing.
Let me enter matter be heard.
yes, my lord.
Madam.
At this stage, I have objection to releasing them.
Then you will also fix the matter for hearing matter.
Yes, I am ready for finally. And the LCR also received.
Let's say receive matter.
So is any other respondents is yet to appear or all of all the respondents have already appeared? You are the claimant respondent.
I am reckoning.
So you are numbered as respondent number?
Respondent number 1.
That's not one matter.
Only one.
Yes, there is one respondent, this owner of the vehicle.
Huh?
One more respondent, the owner of the vehicle.
Notices served.
Notice has been served on them.
If notices served, then you will not fix the matter for
We
hearing.
have sent the
You have sent the notice served or
Served.
yet to be?
notice already served. I have to check whether notice has been sent, but
We have not received back the notice.
because
It is already you have taken state.
yes,
Right,
you
but
know,
notice
yes,
is
and
not
it was sent on the correct address as mentioned in the learned code below. The same address I have sent the notice. And the matter is regarding the policy.
But the question is that the owner produced that said policy which you are saying as a fake one, isn't it?
Mhm.
So I think owner is also a necessary party in this.
Mm.
Otherwise, in their absence, how can we fake? Because they file the insurance may be fake or may be genuine, whatever. But they are the claimants on.
They are
We are the claimants.
Yes.
We
So the presence of this respondent number 2 is very much essential, I think. So we have not received back the this notice till date. Let this service be awaited till next date of listing or what?
maybe.
Or you can track the consignment. No? You can also file your track consignment report or registry may be directed in that regard. If your this I mean this address is proper, don't know.
Madam, while admitting the matter, my lord,
It happened. Study. Await. Either we have to await the service till next date of listing.
Right.
Or if it is not supposed received, then you may file the track consignment report or registry may also be directed accordingly. Let us see, find out first.
Registry may also be directed because the record is with the court. We have taken the steps,
So
deposited.
initially, first we will await for the service of notice till next date of listing. Maybe listed immediately after vacation then.
Yes, ma'am.
Here you want any fixed date here? In that case, it will go up to February. Otherwise, we are listing it
Look,
immediately after.
I am suffering, my lord. He is not suffering.
Yes, I am also ready to hear.
I am suffering, my lord,
Because
because my lord, prima facie, my lord, the first date of my lord, admitting that matter, my lord, it was directed to my lord, deposit 25%.
it is the
On that day, my lord, they have no opposing. Now, my lord, when I file this, my lord, petition, they are opposing, my lord.
because for staying the
My lord,
condition is there.
for stay, my lord, reasons, they have deposited 25%. And when I file this petition, my lord, they are opposing, my lord.
Because the main thing is the policy. When we have,
That,
we have
that
not
was
sued
already,
the policy.
Learned Court has already satisfied that 25% deposit, then also only Mano stay has to be granted. Now they are opposing, after
besides-
getting the Mano 20 Mano stay order, now they are opposing. my lord.
Besides insurance policy, there are other vital points also.
That point has to be raised by the first day, my lord,
No.
before my lord
No,
admitting.
we have raised, but
When the matter is admitted, my lord, they are ready to, my lord, deposit 25%. Now, when I file a petition, my lord, they are opposing, my lord. Only for that stay reasons, my lord, they have deposited. Now, otherwise, my lord, you don't sit fixed time, my lord.
so this honorable court has imposed the condition that for
That
staying the,
condition is imposed, my lord, to satisfy, my lord. That I am entitled, my lord.
let the
That
matter
was
be
what
heard
25%
finally,
is-
your lordship. After final hearing.
Yes, your lord, now I am suffering, my lord. It's a case of, my lord,
It's a matter of 1 month maximum.
it is a case of, my lord, 2019. From 19, my lord, I have not getting a single payment.
So a judgment was 24 only.
Judgment is of 24.
The
Judgment
case
was
was filed in 19, not 2019.
No, only after judgment you will get the amount. So let the matter be heard finally, your lordship.
Heard Mr. P.P. Jain, the learned counsel for the applicant. Also heard Mr. K. Kanika, the learned counsel. As per the office note dated 10/11/10/12/2025, the service is still awaited for the response number. Let the service be awaited till next date of listing. In the meantime, the registry is also hereby directed to report the track consignment, to raise the track consignment report before the court or the next date of listing. LCA has already been received.
Yes.
LCA has already been received. So the matter may be listed for hearing if the service be completed on or before the next listing. Registry will
Date may be fixed, my lord, or is it again, my lord?
March. Okay.
5th of March.
5th of March. Okay. If your withdrawal I was numbered as
4008, man.
4008 or depot. Let the matter be accordingly. In this matter also may be heard along with mail.
Diploma.
May I please, Your Lordship? Your Lordship, I have filed this interlocutory application, Your Lordship, for condonation of delay, Your Lordship, for 38 days while preferring this miscellaneous first appeal, Your Lordship.
Here the deputy SGI is there.
Yes, Your Lordship.
If we present then matter we can have dispose of the matter itself.
Yes, Your Lordship.
He's not here, na?
Not yet.
Could have served the notice to the Union of India earlier than their presence with India.
Yes, Your Lordship. I have already served them a
copy.
Yes, sir.
They are how many days? 38 days only.
Yes, Your Lordship. Your Lordship, the primary reason being,
No,
Your
no,
Lordship.
that's okay. 38 days. That's what I'm saying. You can
Yes,
have
sir.
only delay, but let them appear then otherwise.
Yes, sir.
You are Mr.
D.S. Dekka, Your
D.S.
Lordship.
Dekka. D.S. Dekka, the land the applicant. Applicant. It's an application, section 5 of the limitation agreeing for condonation of delay 38 days and preparing the accompanying miscellaneous first appeal against. Where is the judgment and what?
Yes, Your Lordship.
Judgment,
Judgment and order dated, Your Lordship, 36/2025.
judgment and order dated 36, 2025 in
In
OA.
original claim application number IIU
A number II Tangor I na IIU 103 of the issue notice to the Union of India of the respondent. We are not fixing any date immediately after verification. We have
Yes, Your Lordship.
let the matter be listed immediately after verification. As on a date.
Much obliged, Your Lordship.
Please, Lordship. Lordship, this appeal is prepared by the insurance company, Lordship, and there is an IA for condoning the delay of 31 days.
How many days? 31
days.
Your Lordship, in this case, I have instruction to appear on behalf of opposite party number 1, 2, and 3, who happens to be the claimant.
One.
So, Your Lordship, only 31 days delay. So, Your Lordship pleases, it can be condoned. And they may be directed to serve copy of.
You are Mr.
एक Kakoti, Lordship.
A. Kakoti. Part Mr. A. The learned counsel for the applicant. The learned appearing as per instruction. One. It's an application section 5 of limitation. For condoning the delay of 1 days in filing the connected appeal against the judgment and award dated 3/05/2025. The learned member MSCT number 2, M. Guwahati in MSC case number F65 of it. It is why you have explained any reason here? In which para?
Yes, Lordship. The delay was explaining in the para 2 to 7, Lordship.
So basically, for official formality or what?
Yeah, this is
Submitted that Mr. Submitted that there was 1 day's delay in preparing the connected appeal, as some time was required for doing some official formalities before preparing it. Next, Mr. Monbal, who is appearing by instruction of this one is objection. There is no objection and submitted that he has no objection if the matter is registered and delay is complete. In view of this, and considering the ground mentioned in the application, the delay of 31 days in preparing it, let me see, with the direction to the direction to the register and number taken this. Further, the applicant applicant is hereby directed to serve copy of the memo appeal to the respondent number 1 and 3.
Your Lordship, my name may be reflected while.
Further, the registry is also hereby directed to reflect the name of Mr. Monda as and when the matter will be listed.
Highly obliged.
obliged.
May please your lordship, there is a condolation of delay for 651 days.
651. Also big delay.
Notice may be
Yes. Your MS. Your MS
P board lo.
P board. Part MS P board. You done it. This is an application. Section 5 recommendation frame for condonation of delay for a period of 651 days. In preparing the connected appeal against the judgment and award dated 3/10/2023 in MSC case number 4 of the
4 of the 2020 year.
issue notice to all the respondents should be estimated accordingly after
4 weeks.
after 4 weeks after 4
I appeal your lordship. Lordship, this is for condonation of delay. Delay is of 27 days, lordship. My friend is appealing for a claimant, and he has no objection.
I'm for respondent claimant.
payment response.
Respondent number 1.
Objection.
No objection.
Why 2 filing number?
Check.
I mean, one IA is of 25, 2026.
Lordship.
Another
Another is
of
MSC appeal, and there is an I for stay also.
stay will come later. So now your IA for condonation is 25.
25, lordship.
Okay, it was also there.
Yes, Lordship, I am filing paper.
You have filed.
Yes.
Was there any need of filing the KBL? Because they are not going to open anything. KBL to discharge. Part Mr. You are Mr. Arsham.
Arsham.
Part Mr. Arsham. Done it constantly. And also part Mr. P. Gogoi.
P. Gogoi.
P. Gogoi. They done it constantly. Appealing for the claimant respondents number
1.
1. This is an application section 5 implementation for condonation of delay of 27 days in preparing the appeal against the judgment and award dated 26/06/2025 passed by the learned member MSCT in MSCT number 2 Kamrup N in MSC case number 2054. Next is submitted by Mr. Sharp. There was a 27 days delay in preparing the appeal, only as some time required for observing some official formality in preparing. These are the main
Lordship.
formality in preparing the Mr. Gokun expert. Mr. Gokun done it for the claimant respondent raised no objection and submitted that he has no objection if the delay is expert considering submission made by land considering the grounds mentioned in the appeal. Okay, sorry, present application. The delay is continued. Your name should be reflected.
Yes.
Name of Mr. Google may be reflected. The respondent. Okay, we have
Mr.
exposed the
P. Gogoi and Mr. H. Das.
age just no, we have not seen the age just here.
In the Wakalatnama already signed.
You are here, your name has been reflected here, so we are reflecting here now. You know, one is just also.
My senior.
Who is just foreign das?
Foreign das.
Okay then. Okay, his name will be also.
Oblige.
Oblige, Lordship.
This criminal revision petitions stands dismissed.